Cause number 20 CPR 0136.
Thank you, ma'am. You may proceed.
I called Dwayne Hanson to, please. Mr. Hanson, would you state your name, please?
Dwayne Hanson.
And Mr. Hanson, you are named as the executor in the will of Clarence Gene Wynn,
Yes, ma'am.
and he was your grandfather, is that correct?
That is correct.
Okay. And the will was filed on December 7th, and the original will was delivered December 10th, 2020, correct?
Yes,
And you submitted a copy of the last will and testament of Clarence Gene Will dated January 31, 2013, correct?
through Jay
And you
Johnson.
Excuse me?
I believe it was sent to you by Jay Johnson.
Correct. And
Yes.
you recognize his signature on the will?
I do.
Okay. And decedent died on August 3rd, 2020, correct?
Correct.
And 4 years have not elapsed since the date of his death and the filing of the application, correct?
As far as I know, correct.
And no objection or contest of the probate of the will has been filed with the court, correct?
Correct.
The decedent executed the will and it was witnessed, but under Texas law, we required a notarization, and this will does not contain a notarization. So you recognize the signature on the will as his will, correct?
Correct.
And he was over 18 and of sound mind at the time he executed the will.
Yes, ma'am.
And he did not revoke the will.
Not to my knowledge, no.
And after the will was written, no children were born to or adopted by the decedent after the date of the will.
No.
And after the date of the will, decedent's wife, Patricia Wynn, died on February 23rd, 2013, and decedent was married to Shirley Ann Wynn at the time of his death, correct?
Correct.
And no state, governmental agency, or charitable organization is named in the decedent's will as a devisee, correct?
Correct.
And there's a necessity for the administration of the decedent's estate, correct?
Correct.
And the decedent named his wife, Patricia Wynn, to serve as his executrix, but she died before he did. And he named you as the substitute independent executor to serve without bond, correct?
Correct.
And you are entitled by law to letters testamentary, and you are not disqualified by law from accepting letters testamentary, correct?
Correct.
You are not a Texas resident, and you have appointed me, Amy Rose Oliver, as to be your resident agent, correct?
Correct.
Will you tell Joe that I'm in probate, Robin, please?
I beg your pardon?
Melinda,
I'm sorry. I'm
you
sorry.
probably need to mute.
Oh, okay. This is not a taxable estate, and there is no necessity for the appointment of appraisers for this estate, correct?
Correct.
And the interest of the estate requires the appointment of an independent executor, correct?
Correct.
So you're asking the court to admit this will to probate and to appoint you as the independent executor to serve without bond, correct?
Correct.
And upon the court admitting this will, you'll take the oath and do your job according to Texas law, as I will help you to do, correct?
Absolutely.
Okay. That's all I have for this witness, Your Honor. I call Mr. Johnson.
You may proceed.
Mr.
Good
Johnson,
morning.
would you say, Mr. Johnson, would you state your name, please?
Jay Johnson.
Okay. And you actually delivered the original will to the court, is that correct?
That is correct.
And you recognize the decedent's signature on the will?
Yes,
Okay. And how did you know the decedent?
I've known him about 35 years, both as a friend and a client.
Okay. Okay. And he was over 18 and of sound and disposing mind when he signed the will.
Yes,
Okay. Your Honor, that's all I have for this witness.
Okay, call your next witness.
I call Mr. Gene Wynn. Mr. Wynn, would you state your name for the record?
You're muted, Mr. Wynn. I can read your lips, but you're muted.
Gene Allen Wynn,
Got it.
And Mr. Wynn, how did you know the decedent?
my father.
And do you recognize his signature on the will?
Yes, I do.
And he was over 18 and of sound and disposing mind when he signed the will, is that correct? Your Honor, that's all I have for these witnesses. We're asking that you admit this will to probate and appoint Mr. Dwayne Hanson as the independent executor to serve without bond.
Okay, everybody admits the will of probate and authorized letters. Thank you all. Have a great day.
Thank you very much, Your Honor. We'll have all the proof of death and the affidavit signed and e-filed before you sign the order, and then we'll sign the oath after you sign the order.
Yes, ma'am.
Thank you very much. May we be excused?
Yes, ma'am, you may.
Thank you very much. Have a great day.
Thank you, you too. Call number 141, the state of Norma Jean Seal. Ms. Rendon. Good
Good
morning.
morning, Your Honor.
All right. You may proceed, ma'am.
All righty, Your Honor, I'm here to probate the will of Norma Jean Sill. Decedent died on December 2nd, 2020. Decedent's date of death was less than 4 years ago. Decedent was a resident of Chambers County at the time of her death. The original will was filed with the court on December 29th, 2020. I'm looking at a copy of the purported will dated August 19th, 2011. I do recognize that to be the will of Norma Sill, and to the best of my knowledge, she did not revoke her will. She was not married at the time of death, nor was she divorced after the date of the will. There are no children born to or adopted by decedent after the date of the will. There's no state government agency or charitable organization named as a devisee. There is a necessity for administration. The will names her daughter Cynthia Griffin as her executrix, and she's qualified and not disqualified to serve as such. The will self-approved, states non-taxable, and we request the appraisal be waived, Your Honor.
Okay, everybody admits the will of probate, authorized letters. Thank you, ma'am.
Have a good day. May I be dismissed?
You may be. All right, calls number 104, the state of Glenda Diane Trent. Mr. Gunn, good morning.
Good morning, Your Honor.
You may proceed, sir.
Okay, yes, sir. Can you hear me, Your Honor? I believe
I can hear you, sir.
yes, sir. Okay. I'm calling Carol Rutledge as the witness for purposes of proving this up. Ms. Rutledge, would you state, you are Carol Rutledge, and would you state your relationship to Glenda Diane Trent?
Ms. Rutledge, you are muted, ma'am.
You're muted. Carol?
Okay, now, is that better?
You got, yes, ma'am.
Yes, ma'am.
Okay.
Our Judge Sylvia and I were having a hard time with our lip reading. We hadn't gotten a refresher course here lately. Okay.
Okay,
Will you,
Okay.
please, ma'am, will you tell the court how you are related to Glenda Diane Trent?
we're sisters.
All right. And Ms. Trent died on or about August the 21st of 2020 in Anahuac, Chambers County, Texas, at the age of 72 years, and 4 years have not elapsed since the date of her demise.
That's correct.
She had a fixed place of residence in Chambers County on the date of her death. Is that correct?
Yes, yes, that's correct.
You have examined the document which purports to be her last will and testament, which is dated March 21, 2007. Is that correct?
Yes,
And in fact, I believe that you prepared that document, did you not?
yes,
Okay. Since the date of the execution of that document, have any child or children been born to Ms. Trent?
no,
And has a marriage of Ms. Trent been dissolved?
no,
Neither the state of Texas, an agency of the state of Texas, or an eleemosynary institution been named as a devisee in the will.
no,
Okay. The will names your brother-in-law, Carlton Wheeler Trent, as the independent executor. Is that correct?
yes, it is.
And to your knowledge, he is qualified to serve in such capacity and is not disqualified.
That's correct.
Okay. And the estate is a non-taxable estate, and you're asking that the court waive any appraisers in this. Is that also correct?
Yes, it is.
Okay. And the will was made self-proved in the manner as prescribed by law?
Yes,
And the two witnesses are Mary Sanders and Earl Sanders. Is that correct?
that's correct.
And neither of those people have any interest in this estate.
No,
You're asking at this time that the will be admitted to probate and that Carlton Wheeler Trent be appointed as the independent executor of the estate of Glenda Diane Trent.
yes,
And I didn't ask you, but you recognize the signature of Glenda Diane Trent on that particular document, which purports to be her last will and testament.
yes, I do.
To your knowledge, did she ever revoke or amend that document?
Not to my knowledge.
And was she of sound and disposing mind and memory at the time she executed the document?
Yes, she was.
Your Honor, we have nothing further. We would ask that the last will and testament of Glenda Diane Trent be admitted to probate, that Carlton Wheeler Trent be appointed as the independent executor. We will file today a proof of death and other facts which need to be corrected from the one that has been filed. And I believe the order has already been submitted for the appointment of Carlton Wheeler Trent, the husband, as the independent executor. And we would rest.
Probate and authorized letters. Thank you, Counselor. Thank you, ma'am.
And may we be excused,
You
John.
may be excused.
Thank you.
All right, cause number 127, the state of Brian Neal Coffey. Ms. Shows, good morning. You are muted, ma'am.
There we go.
Okay,
There you go, and you may proceed.
can you hear me now, Your Honor?
We can hear you.
Okay. I have three witnesses that need to be sworn in.
All right, raise your right hand, please. Linda, you're muted.
Yes,
Muted. No, we're not muted.
Melinda, you're muted.
His clerk's muted.
That's my clerk.
Am I still muted?
No, you're good.
Okay. Do you swear from the testimony you're giving today is true and correct, so help you God?
Yes.
All right, you can put your hand down. and-
Did y'all hear me?
Yes.
Yes, you may proceed, Counselor.
okay.
No, I
Your
can't
Honor,
hear him.
We're here to probate a copy of the last will and testament of Brian Neal Coffey. And Mr. and Ms. Fontenot here are witnesses that are going to prove up the handwriting and the signature of the decedent. And so with your permission, I will go through and ask them various questions.
You may proceed.
Rather than going through it twice, I'm going to, if it's all right with you, I will ask each of them to respond at the end of the presentation.
That'd be great, sir.
Okay. Is it true, Mr. and Ms. Fontenot, that you were personally acquainted with Brian Neal Coffey and was well acquainted with his handwriting and signature? There's a document dated June the 10th, 1985, which a copy has been shown to you, and which is a copy, and is purported to be a copy of decedent's last will and testament, and the signature is his and has been subscribed there too. And on the date that he signed the document, he was of sound mind and attained the age of 18. Is that correct?
Yes.
Yes.
Yeah.
Okay. Now, now I have Patricia Delane Coffey, who is who is requested to be the independent executrix of this estate. Ms. Coffey, is it true that your husband Brian died August 25th, 2020 in Beaumont, Texas, at the age of 62? 4 years had not elapsed from the date of his death. He was domiciled and had a fixed place of residence in Chambers County. The document dated June 10th, 1985 Reportedly, a copy of his will was never revoked, as far as you know. That a copy of the will was self-proved and is being offered with proof of decedent's handwriting and signature. A necessity exists for the administration of this estate. No child or children were born or adopted by the decedent after the date of the will, and after the date of the will, no marriage of his was dissolved. That you are not disqualified by law from accepting letters testamentary in this estate. Is that correct?
Yes.
I have no further questions, Your Honor.
Okay. Hereby admit the will of probate and authorized letters, Counselor. Thank you.
Okay, thank you, Your Honor. We will, I will send a executed proof of death and other facts, and as well as proof of decedent's handwriting and signatures for the records there, and as well as the. Do you want me to have her sign the oath and send it to you, or do you want to wait till the judgment is signed?
Yes, well, let's wait till the judgment signed, Counselor.
Okay, that'll be fine.
All right, thank you.
Thank you, Your Honor.
Thank you.
Have a good day.
You too.
All right, cause number 133, the state of Gregorio Villarreal. Mr. Strong, good morning.
Good morning, Judge. Had to find I'm here also someplace.
All right, you may proceed, Counselor.
This time I'll call Courtney Villarreal. Are you there, Courtney?
I'm here.
Did you get sworn in? Were you online?
I did.
Okay.
I
All right, Mr. Please state your name for the record.
It's Courtney Villarreal.
And you're well acquainted with the deceased because he was your husband, correct?
Yes.
And your husband passed away on October 16th of 2020 at MD Anderson Hospital in Houston. Is that correct?
Yes.
But at the time he passed, he was a resident of Harris County, living at 109 River Oaks Drive in Baytown, Chambers County, Texas. Is that correct?
Yes.
All right. Now, normally at this point, the judge would hand me the original will to show you, but you gave me his original will sometime back, right? You've kept a
Yeah.
copy of it.
Yes, sir.
And I've followed that with the court, and you've seen that, and you were testifying that is his last will and testament to the best of your knowledge. You recognize it as such.
Yes, sir.
Okay. Now, did he ever revoke that will?
No.
All right. Does that will name any governmental entity or charitable organization as a beneficiary?
No.
All right. Now, you're telling the court there is a necessity for administration or as a house and some assets to be distributed, correct?
Yes.
All right. Now, was your husband ever divorced?
No.
All right. Were there any children born to him after he made that will?
No.
All right. Now, Ms. Villarreal, you and I discussed the qualifications to be an executor because he named you as executor of his will, correct?
Yes.
And you remember that discussion about what the qualifications are?
Yes,
And
sir.
you're representing the court that you are qualified to serve as executor of your husband's estate. Is that correct?
Yes.
All right. Your Honor, the will is self-proved as required by the Texas State Code. It's well under the size for being a taxable estate. We ask that appraisers be waived and that Ms. Villarreal be named as executor and issued letters.
So done. Everybody admit the will to probate and authorized letters. Thank you, Counselor. Ms. Villarreal. Take care.
Thank you.
May we be excused, Your Honor?
You may be.
Thank you.
Thank you.
Thank
Thank
you.
you. Last but not least, number 135, the state of Lester Ray Williams. Good morning.
Can you hear me, Judge?
Can hear you.
Okay, we're ready.
Have you been sworn in, Ms. Williams?
Yes, she had,
You may proceed.
yes, he has. Okay, Ms. Williams, you have filed the will for probate in the estate of Lester Ray Williams.
Yes.
And Judge would ask the court to take judicial notice of the file that includes the original will of Lester Ray Williams dated February the 6th of 2002. And also she has executed and sworn to a proof of death and other facts which we have filed with the court. And I'd ask the court if it take judicial notice of those. I can ask her all the questions or to make it shorter, we can just ask you to accept that as her testimony.
All right, the court will accept that. You received that, Melinda, correct? Shake your head up and down. Okay,
Yes,
that's great.
that's correct. Everything in it, you've signed,
Correct.
sworn to it.
Yes.
And it's a non-taxable estate. And would ask that appraisers be waived and the court order that the will be probated.
By Mr. Will of probate and authorized letters. Thank you, ma'am.
Thank you.
Have a good day.
Thank you.
Thank you.
Ladies, we're done. You're muted, Melinda.
Thank you.
Thank you. That's okay. Hey, it worked. We're done. A little confusing, but we made it happen. You're still muted, Melinda. Adios.